So G Plus Communications and Samsung. G Plus Communications is a non-practicing entity, which was the claimant in the present case here, asserting patents against Samsung, which had belonged to ZTE before. And Samsung was on the defendant side in these proceedings. Some background on this case. There had been some discussions for a license agreement between ZTE and Samsung already back in 2019. So the parties started negotiating about a license for ZTE's portfolio, and the discussions were ongoing for a while. Then when the discussions were still ongoing, but some new developments came in August and September 2020. There was G Plus Communications, which was founded in August 2020, and this was a company which we could characterize as a special purpose vehicle, which was created in coordination with ZTE, and had also specific links to ZTE. First of all, shortly after it was founded, it bought the 3 patents that were relevant in the present proceedings here from ZTE. But there was also some other form of coordination or cooperation between the 2 companies. For example, based on the agreement between ZTE and G Plus Communications, ZTE would receive 20% of the net royalty generated by G Plus. And there was also an obligation that it would be assisting G Plus in its licensing efforts. So G Plus Communications and ZTE were 2 companies that were linked to each other, and also the companies from which the patents originated that were asserted here in the present case. Now, although the ZTE was still in negotiations with Samsung when G Plus was founded and the 3 patents in suit were transferred, it did not inform Samsung about that, but just went on with the negotiations, which indeed were successful. Almost a year after, in July 2021, ZTE and Samsung signed the license agreement. But of course, at that moment, the patents that had been sold to G Plus Communications a year ago were not included in the agreement. So what happened afterwards was that G Plus reached out to Samsung and asked Samsung to take a license on the patents it had acquired from ZTE before. Now, this did not happen, and in March 2022, G Plus Communications filed the present action against Samsung before the U.S. District Court for the Eastern District of Texas. The outcome of these proceedings was positive for G Plus Communications. In January 2024, a jury found Samsung to infringe 2 of the 3 patents in suit and awarded damages to G Plus, which amounted to $67.5 million. This ruling was changed in April 2024 after a retrial. There, the court had some concerns that the jury might have not been pretty clear about the difference between running royalty and the lump sum payment, etc. So the court ordered a retrial regarding the award for damages. And indeed, this award changed, and it became even better from G Plus Communications' view, because the amount awarded to G Plus was even higher with this after the retrial. It was $141 million for the infringement of the 2 patents. Interestingly, here almost 60 millions were attributed to 1 patent, and the rest, 81 millions, were attributed to the other patent. After this jury award was there was a very interesting development. The PTAB invalidated one of the 2 patents in suit that has been found to be infringed in the proceedings, and particularly the patent that had the higher amount of damages was invalidated. So the one that had almost $80 million of damages. As far as we could see, the other patent has being attacked as well. So there might be also some new developments regarding the validity of the second patents. But in any case, here in these proceedings, of course, there should be expected that more episodes will still come, since now we have on the one hand an award for damages, and on the other hand at least one of the patents which has been used in order to found this award has been invalidated in the meantime. In our case, we are going to take a look at two decisions of the court, or two opinions of the court, which were delivered before the jury had granted the damages initially. And here the court dealt with specific questions, responding also more or less to respective motions of the parties. Very generally, what was the context of these decisions here was what kind of pleadings the parties could produce to the jury, what kind of evidence the parties could produce to the jury. So this were a part of the decisions here. This is the background also of the decisions that we're going to discuss today. So the first opinion was delivered on the 8th of January by the district court, and revolved around one major question, which was whether Samsung, as the defendant here, was in a position to impute ZTE's conduct before the sale of the patents to G+, in order to show that G+ had breached its front duties. So in other words, Samsung had argued in the proceedings that there should be no remedies in the present case because G+ was not fulfilling its front commitment or the duties arising from a front commitment that is relevant for the patents here. And in order to show that, Samsung did not only want to focus on the conduct of G+ itself, but also focus on the conduct of ZTE before the sale of the patents, basically arguing that you cannot differentiate between the two of them. Now, the court said that this should not be the case, that Samsung should not be allowed to impute ZTE's behavior in order to show that G+ was not in line with its front duties. However, the court said that Samsung should be allowed to present relevant evidence to defend itself against the allegation of willful infringement, meaning that although this information or this evidence should not be used in order to establish a defense against the claims that G+ had raised here based on a potential breach of obligations on the side of G+, you could use this information in order to defend yourself against another allegation which was also pending in these proceedings, the allegation of willful infringement. So we're going to see in a moment what exactly this means. But let's turn first of all to the main question of these proceedings. So here the question was, can ZTE's conduct before the sale of the patents be relevant or be attributable or accountable to G+? This was the main question. This was a key question here. And the court said no, this could not be the case because in the eyes of the court, Samsung did not establish that ZTE's conduct constitutes an encumbrance burdening the patents in suit. What does this mean? What Samsung basically argued was to say that, look, if you have a patent that is under a front commitment, then this means that the behavior of the patent owner is, in a sense, attached to the patent. It follows the patent. So even if the patent is transferred, this the way the patent owner has behaved before is something that is transferred with the patent, to put it very simple. So the behavior here more concretely of ZTE before the sale of the patent is something that should follow the patent, even if it's now owned by G+. The court found, however, that this is not the way things are under French law, which is the law which would be applicable in the present case. Why French law? French law was applicable here because the front undertaking was a front undertaking under the ETSI IPR policy, and the ETSI IPR policy is subject to French law. So this question should have been answered by French law, and this is what the court actually did here. It heard witnesses of French law from both sides and found, basically concluded what French law says regarding the specific question. And the court was convinced that under French law, it is not allowed to impute the predecessor's conduct to the successor in interest. What does this mean in a context like the one we're talking about today? That French law would not allow to impute the conduct of the seller to the contract of the one who has bought the patents. This is called the privity rule, which the French law follows. And in other words, it means exactly this, that a buyer of goods or rights is in principle not bound to the contract which the previous patent the transferor has entered into, and is also non-liable for any breach of contract of the latter. So to visualize this, under French law, when you have a transfer of rights, which would include patent rights here, you have a cut. So the rights or the obligations that the previous patent holder had entered into do not follow the patent when it's transferred. So this was here the main reason why the court dismissed this view that Samsung had taken. Basically because under French law, there is no such thing as transferring the obligations or transferring the behavior together with the patent. Now, what Samsung tried to do is to refine its argument a little bit by saying, yes, this might be the situation under French law, but what you should not do here is to consider that G Plus is a successor in interest compared to ZTE. On the contrary, what Samsung basically argued is that G Plus is the alter ego of ZTE. In other words, it's more or less one and the same company or one and the same entity. And why is that? Because, as we have said, there is a very close link between G Plus and ZTE. G Plus was founded in coordination with ZTE. ZTE has a significant holding still on the royalty which G Plus will generate. It has an obligation to help G Plus in its licensing efforts. So here the argument of Samsung was, if you look all this, then it's basically the same company, the same entity. So there is no question whether the duty of ZTE should be transferred along with the patent or not, because we're talking about one and the same entity, one and the same person at the end of the day. The court, however, was not convinced that this is the case. It found that Samsung was not able to show sufficient fact that G Plus is actually the alter ego of ZTE and cannot be distinguished from ZTE. So this argument also was not successful in the present case. Finally, there was also a, let's say, more technical reason why the court did not follow this argument of Samsung. The court concluded that Samsung did not give proper notice to G Plus regarding this line of argument in the proceeding, which means that the latter was not in a position to counter that effectively. So also for this reason, this argument should not play a role in the proceedings. This more technical, let's say, formal reason. So the court said, no, the conduct of ZTE cannot be used to, in the context of a potential breach of front duties by G+, but as we said already, it can be used by Samsung in order to defend itself against the allegation of willful infringement. This is again a different angle. So on the one hand, we're talking about potential breach of duties under a front commitment. Here, the question is, did Samsung know that it is infringing, and did it infringe the patent willfully, which would lead to a higher damage award. The court said, in this context, when we're talking about willful infringement, the discussions or the negotiations with ZTE are very relevant and therefore should be presented to the jury and should be used in the proceedings. Why is that? Because the court said if Samsung, which was negotiating with ZTE and already before G Plus had been founded and the patents had been transferred, if Samsung could reasonably believe that the patents in suit here were included in the license agreements which it signed with ZTE after the transfer of the patents in suit to G Plus, then it would be very hard to say that Samsung willfully infringed the patent, exactly because it was, at least in the impression, under the impression that it was negotiating a license that would cover these patents as well. So that's why the court said this conduct of ZTE should be presented in this context to the jury, and Samsung should be allowed to do that. What could be relevant, for example, the timeline of the license negotiations with ZTE and Samsung, the fact that ZTE knew and failed to include the patents in the license, or it had not informed that Samsung about the transfer of the patents to G+, or even the fact that ZTE holds a share of 20% of the licensing revenue of G+. So all of these facts in the eyes of the court are relevant, and Samsung should be allowed to show this in the proceedings, however, only with respect to the allegation of willful infringement.